All right, good morning. Thank you for your patience. I assure you that we were working while you were waiting. That will happen from time to time. I appreciate your patience. Members of the jury, you have been selected and sworn as the jury in this case. I'll now give you some instructions explaining how the trial will unfold. I'll give you a larger set of instructions at the end of the trial explaining the law. You are required to consider and follow all of the court's instructions. The defendant is accused of committing one or more crimes. You'll decide if the defendant is guilty or not guilty. Please keep an open mind throughout the trial. At the end of the trial, you will discuss the evidence and reach a verdict. You took an oath to well and truly try the issues pending between the parties and to render a true and just verdict. The oath is your promise to do your duty as a member of the jury. Please be alert, please pay attention, and please follow the court's instructions. The prosecution has filed a document called an information that contains the charges against the defendant. The information is not evidence of anything. It is only a method of accusing a defendant of a crime. I'll now read the information. Count 1, criminal homicide, aggravated murder. Between on or about March 3, 2022 and March 4, 2022 in Summit County, state of Utah, the defendant did intentionally or knowingly cause the death of another individual under any of the following circumstances. The actor committed homicide for pecuniary gain, and or the actor committed homicide by means of the administration of a poison or of any lethal substance, or of any substance administered in a lethal amount, dosage, or quantity. Furthermore, the defendant was a cohabitant with the other individual. Count 2, attempted criminal homicide, aggravated murder. On or about February 14, 2022, in Summit County, state of Utah, the defendant did intentionally or knowingly attempt to cause the death of another individual under any of the following circumstances. The actor attempted to commit homicide for pecuniary gain, and or the actor attempted to commit homicide by means of the administration of a poison or of any lethal substance, or of any substance administered in a lethal amount, dosage, or quantity. Furthermore, the defendant was a cohabitant with the other individual. Count 3, insurance fraud. Between on or about January 29, 2022, and on or about August 31 of 2022 in Summit County, state of Utah, the defendant did, with intent to deceive or defraud, intentionally, knowingly, or recklessly devise a scheme or artifice to obtain anything of value by means of false or fraudulent pretenses, representations, promises, or material omissions. Furthermore, the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. Count 4, insurance fraud. On or about June 14 of 2022 in Summit County, state of Utah, the defendant did, with intent to deceive or defraud, present or cause to be presented any oral or written statement or representation as part of or in support of a claim for payment or other benefit pursuant to an insurance policy, certificate, or contract, knowing that the statement or representation contained false, incomplete, or fraudulent information concerning any fact or thing material to the claim. Furthermore, the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. Count 5, forgery. On or about January 29, 2022, in Summit County, state of Utah, the defendant did, with the purpose to defraud someone, make, complete, execute, authenticate, or utter a writing, so that the writing or the making, completion, execution, authentication, or utterance purports to be the act of another person, whether that person is existent or non-existent. The defendant has entered pleas of not guilty and denies committing the crimes. Every crime has component parts called elements. The prosecution must prove each element beyond a reasonable doubt. Until then, you must presume that the defendant is not guilty. The defendant does not have to prove anything. The defendant does not have to testify, call witnesses, or present evidence. The prosecution has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true. In criminal cases, the prosecution's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there is a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find the defendant not guilty. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crimes charged. This presumption persists unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. Regarding our respective roles, all of us, judge, jury, and lawyers, are officers of the court and have different roles during the trial. As the judge, I'll supervise the trial, decide legal issues, and instruct you on the law. As the jury, you must follow the law as you weigh the evidence and decide the factual issues. Factual issues relate to what did or did not happen in this case. The lawyers will present evidence and try to persuade you to decide the case in one way or the other. Neither the lawyers nor I decide the case. That is your role. Do not be influenced by what you think our opinions might be. Please make your decision based on the law given in my instructions and on the evidence presented in court. As jurors, you'll decide whether the defendant is guilty or not guilty, and you must base your decision based only on the evidence. Evidence usually consists of the testimony and exhibits presented at trial. Testimony is what witnesses say under oath. Exhibits are things like documents, photographs, or other physical objects. The fact that the defendant has been accused of a crime and brought to trial is not evidence. What the lawyers say is not evidence. For example, their opening statements and closing arguments are not evidence. You must keep an open mind throughout the trial. Evidence can only be presented one piece at a time. Do not form or express an opinion about this case while the trial is going on. You must not decide on a verdict until after you have heard all the evidence and have discussed it thoroughly with your fellow jurors in your deliberations. Rules govern what evidence may be presented to you. On the basis of these rules, the lawyers may object to proposed evidence. If they do, I'll rule in one of two ways. If I sustain the objection, the proposed evidence will not be allowed. If I overrule the objection, the proposed evidence will be allowed. Please do not evaluate the evidence on the basis of whether objections are made. Regarding the order of the trial, the prosecution will give its opening statement. An opening statement gives an overview of the case from one point of view and summarizes what that lawyer thinks the evidence will show. Defense counsel may choose to make an opening statement right after the prosecutor, or wait until after all of the prosecution's evidence has been presented, or not make one at all. You will then hear the prosecution's evidence. Evidence is usually presented by calling and questioning witnesses. What they say is called testimony. A witness is questioned first by the lawyer who called that witness, and then by the opposing lawyer. Please consider all testimony, whether from direct or cross-examination, regardless of who calls the witness. After the prosecution has presented all of its evidence, the defendant may present evidence, though the defendant has no duty to do so. If the defendant does present evidence, the prosecution may then present additional evidence. After both sides have presented all of their evidence, I'll give you final instructions on the law that you must follow in reaching a verdict. You will then hear closing arguments from the lawyers. The prosecutor will speak first, followed by defense counsel. Then the prosecutor speaks last because the government has the burden of proof. Finally, you will deliberate in the jury room. You may take your notes with you. You will discuss the case and reach a verdict. From time to time, we'll call a recess. It may be for a few minutes or longer. During recesses, please do not talk about this case with anyone. Not family, not friends, and not even with each other. Until the trial is over, do not mingle or talk with the lawyers, parties, witnesses, or anyone else connected with the case. Court clerks or bailiffs can answer general questions, such as the length of breaks or the location of restrooms, but they cannot comment about the case or anyone involved. The goal is to avoid the impression that anyone is trying to influence you improperly. So if people involved in the case seem to ignore you outside of court, they're not being rude, they're just following this instruction. Until the trial is over, please do not read or listen to any news reports or other reports about this case. Please don't do any research or visit any locations related to this case. And if you observe anything that seems to violate this instruction, please report it immediately to a clerk or bailiff. In the past, jurors have caused serious problems during trials by using electronic devices, such as their phones or their tablets or their computers, to research issues or share information about a case. You may be tempted to use your devices to investigate the case or to share your thoughts about the trial with others. Please don't do that. While you are serving as a juror, you must not use electronic devices for any of these purposes, just as you must not read or listen to any sources outside the courtroom about the case or talk to others about it. You'd violate your oath as a juror if you conduct your own investigation or if you communicate about this trial with others, and you can face personal consequences if you do. So please don't Google the parties, the witnesses, issues, or counsel. Please don't post any updates about the trial on social media. Please don't perform any internet searches at all about anything related to this case. Even using something as seemingly innocent as Google Maps to look up a location, or an online dictionary to look up a term or word that you hear in the courtroom, can result in a mistrial. Please understand that the rules of evidence and procedure have developed over hundreds of years in order to ensure the fair resolution of disputes. The fairness of the entire system depends on you reaching your decisions based only on evidence presented to you in the courtroom and not on other sources of information. Post-trial investigations do occur, and if improper activities are discovered at any time, they'll be brought to the court's attention, and the entire case may have to be retried. So please, be careful. Regarding note-taking, please remember that we do not have transcripts of trial testimony. So when deliberating at the end of the case, you will need to rely on your memory of each witness's testimony. So please feel free to take notes during the trial to help you remember the evidence, but please don't let your note-taking distract you. Your notes are not evidence in and of themselves, and they may be incomplete. All right, we'll now proceed with opening statements. Mr. Bloodworth, let me make sure you have what you need here.